Good afternoon, everyone. I'm Kim Dolan. I'm staff attorney as Kelly for Regional Housing Legal Services. Kelly already introduced us, so I'm just going to briefly kick it off and then hand it over to Dina, and then I'll come back to me, and then we'll end with Mark. So I just wanted to sort of give you an overview. Of. So the purpose of this webinar is really to provide a background and some pretty detailed information about the low-income housing tax credit program, or as we call it, LIHTC or LIHTC, usually LIHTC. And the purpose of this is to help you be a better advocate for your clients who may be living in LIHTC housing or maybe looking for LIHTC housing, and also to let you know generally what, if to the extent you're not aware, who Regional Housing Legal Services is, what we do, who we are, and how we can be a resource for you in your advocacy on behalf of low-income clients. So, so that's sort of the general purpose of this webinar. And we've done this several times. Mark and Dina, and Mark, I think Mark has taken this roadshow to many locations. So.
So that's why he went looking for cookies.
Yeah, that's right.
He always gets cookies when he takes it on the road, right?
I can close that, right? So, all right. Anyway, so yeah, my technical abilities here. I think you're seeing that people are entering the waiting room. I don't know how to get rid of that. So.
Well, it'll keep going until everybody.
Right. Okay. All right. So maybe there's a way to get rid of it, but
at least it's not pinging like it usually does, where it goes ping, 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 ping.
So Regional Housing Legal Services, for those of you who don't know, we're a nonprofit law firm. We're a specialty program of plan, and we're statewide, and we do essentially commercial real and residential real estate development. So. And a lot of that is financed by the low-income housing tax credit program. We do other stuff. We do advocacy. We do community and economic development. We support nonprofits that do that kind of work. So we actually represent the nonprofit developers, and a lot of that is, as I said, driven by or using the low-income housing tax credit program, since that's the main driver of affordable housing development in this country. So, so generally, this webinar is going to go over these basics, which is that LIHTC is a federal tax credit, and it's basically a program of the IRS, not HUD. So, in that way, it's a little bit unusual, and because of that, it's the non-compliance with LIHTC. And the consequences for developers that don't comply are different from other housing programs. And the consequences for tenants that don't comply are also different. So the reason we give this webinar is because we think that you as a tenant advocate can really benefit from understanding how the program is structured in a way that's a little more detailed than just knowing it's a tax credit. So we're going to go into a little bit about what a deal looks like. And I'm also going to talk when the presentation comes to me about how rent is computed, and how rent is really not based on your client's income like it might be if they have a Section 8 voucher or a housing choice voucher, and oftentimes you'll see tenants be paying more than 30% of their income, and I'll try to give you an explanation about why that is. Evictions under the program and non-renewals of leases have to be for good cause. We'll talk about that. A LIHTC unit or a LIHTC building or a LIHTC development will have a restrictive covenant agreement that'll be recorded in the land records, and we'll talk a little bit about what that looks like and how that's enforceable by third parties. And then the last part, which is really Mark Schwartz's bailiwick, is that relationships with your allocating agency are key. And in this case, the tax credit allocating agency is Pennsylvania Housing Finance Agency. So we can talk about how you as an advocate can use those relationships to your advantage and to your client's advantage. So now I'm going to turn it over to Dina, and Dina, I'll keep the controls if you want to tell me when to
Sure.
move.
Yeah, that'd be great. Thank you. So hello, everybody. Happy Friday. I know this has been a great conference, and thank you, Plan, for offering a conference remotely and virtually. I think where, as hard as this COVID process has kind of restrictions have been, there have been these sort of little silver linings where many people can attend events and conferences that they might otherwise not have been able to attend due to travel restrictions, et cetera. So for that, we're grateful. We're very happy that you're here. We do, as Kim said, we do a lot of work within the space of the low-income housing tax credit and the developments that generate from the low-income housing tax credit. Our clients are nonprofit providers of affordable housing. That is, in some ways, it's an interesting tension because while because some of our clients are landlords, our role in helping with that development, in addition to helping our clients structure and understand how to put together a transaction that will result in affordable housing development, is also to make, to help guide them and making sure that they're in compliant with all of the obligations that will benefit the residents who are going to live in their buildings. So while we represent landlords, we're very much advocates for the tenants' rights, and we just want to make sure that that's also how you are understanding like this presentation. So the low-income housing tax credit, as Kim said, this is somewhat of a reinforcement of Kim's overview, is a tax credit. It's sort of role within the structure of financing of affordable housing is an opportunity for private investment to be participants in usually public-private ventures, but it really is an attempt to spur private investment in the development of affordable housing. So how it works is that allocating agencies, and we're going to talk a little bit about the time frame in a minute, allocating agencies such as Pennsylvania Housing Finance Agency receive an allocation of tax credits from the federal government, and then they, through a process called the Qualified Allocation Plan, again, we're going to talk about in a minute, make available to developers a tax credit through a competitive process, an allocation of tax credits. The developers then seek to get bids from investors who are interested in participating with the developer in a development and who purchase an interest in the development itself. And developers use the money that the investors give them to help do the construction and development of that particular project. So the investors invest and they use the funds as capital for construction. I guess that's fundamentally the answer. Credits are very, very competitive, and there's a lot of reasons why investors want to invest in a affordable housing development. Sometimes it has to do with meeting their CRA requirements, Community Reinvestment Act requirements. Sometimes it's for other obligations or other kind of needs to be doing investments in communities. And sometimes it's just a business transaction. But the value, can you give a real life example? A real life example of a development, or a real life example of how much money they might put in. Because we are gonna talk about a project in just a couple of minutes that might help. Is that okay? Okay, well, yeah, from the start. I think we're good. All right, you know what? Let's hold that for a second. We're gonna walk. This is a question from somebody in the chat who's asked us to talk about a real life example. And we have an example in just a couple slides. So if you give a shot, we're gonna walk through just a little bit more of the basics, and then I think we can get to the example, if that would be helpful. Hopefully that will be helpful. So let's just go to the next one, and because maybe it's gonna be helpful to get to the example. Just the context of the low-income housing tax credit, it is a provision. The low-income housing tax credit is a provision within the tax code. It was created by the Tax Reform Act of 1986 and has been modified a number of times. The way that the low-income housing tax credit is administered, it is a joint administration between the IRS and the state allocating agency. So the IRS creates the regulations, and obviously the statute was created by Congress, and the LIHTC rules and regulations require that the allocating agencies sort of implement the rules and administer compliance. Section 42, for those of you who are tax code geeks, is the largest single section of the tax code. It's pretty long, but you would think it would, something that's the largest single section of the tax code would be pages and pages. It's not quite that long, but it is, substantial. But more importantly, that because of the way that we have had a disinvestment of funding for affordable housing through HUD and through other kinds of, just particularly through the federal programs, over time and since 1986, at this point, the low-income housing tax credit and the use of the low-income housing tax credit to help fund and finance the construction of affordable housing accounts for about 90% of all affordable rental housing that's being created today. Since the inception of the low-income housing tax credit, about 3 million affordable housing units have been created throughout the country. And this is a rental housing structure only. There is a provision for how homeownership can be the end result of a LIHTC development, but LIHTC is only addressing affordable rental housing. There are two kinds of low-income housing tax credits. One is called kind of colloquially the 4% credit, one's called the 9% credit. 9% credits are the most competitive, and that's the ones we're most going to talk about today. But your clients can be living in a building, from the outside view, whether your client's in a 4% building or a 9% building is completely irrelevant. This is really just for us who do the development to understand that the 9% credits yield more money for the developers and are very, very, very competitive. That competitive being that they're awarded through the Pennsylvania Housing Finance Agency, and the more competitive, and they're very competitive. So Pennsylvania Finance Agency gets something like 60 to 70 applications per year, and only can fund about 30. For your purposes, one of the most important things is that if a project has been financed at all with a low-income housing tax credit,
probably closer to 80.
Well, I was trying to be, under accounting, probably about 80 applications here. But if, from your perspective, I think, or from all of our perspective, one of the important and essential parts about a development that it was financed with or constructed with an investment that is through the low-income housing tax credit structure is that the development must be compliant for 15 years with all of the rules and regulations of the low-income housing tax credit system program. Everybody calls it something different. And in addition, the federal law requires that the development stay compliant for an additional 15 years. So really it's a 30-year compliance requirement. States may extend that compliance period beyond the 30 years that the federal government requires. And so around the country, different state allocating agencies have created longer, many instances, a longer, what we're calling affordability period. In Pennsylvania, for projects that were awarded an allocation of tax credits in 2019, they now have an obligation to keep the project affordable in compliance with the low-income housing tax credit rules and regulations, so we're going to explain those in a minute, for 35 years. And starting in 2020, any development that is awarded an allocation of tax credits in 2020 and beyond will have a 40-year requirement for long-term affordability. And we're going to talk about what those affordability requirements are in just a minute. So we as advocates for affordable housing throughout the state of Pennsylvania have advocated to the Pennsylvania Housing Finance Agency that it increase its affordability system and keep it and extend it from 30 to 35 and now from 35 to 40. There are just a few exceptions to when a project must maintain these affordability restrictions. These drop down, right? Yeah. So a building that has been financed through the low-income housing tax credit structure must maintain this affordability requirements, the rent and income restrictions, for 40 years. There are a few exceptions to that rule. One is that in addition to some projects, most projects, in addition to being financed with the use of the low-income housing tax credit and the investment that comes through the low-income housing tax credit might also get some kind of a loan in order to either construct or for permanent, to help the costs of construction and or operations. If there is a legitimate foreclosure on that loan, then any foreclosure will wipe out the affordability restrictions. There is something that many of us who are advocates, again, for long-term affordability have worked on, and that is something, not worked on, but have advocated to alert housing allocating agencies to and the IRS, is the idea of a planned foreclosure. And a planned foreclosure is when somebody who has an ownership interest in the building makes a loan to the project and then says, oh, they couldn't pay us back, and then forecloses and then tries to wipe out the eligibility, the affordability restrictions. So if anybody thinks that they might be seeing something like a planned foreclosure, or they have tenants who are living in a building where the tenants say, oh, we just heard that a lender foreclosed on the building and now we're going to lose, there's no more affordability restrictions, we would really like to know that, because there aren't that many actual foreclosures in the tax credit environment. But there is this concern about planned foreclosures. So again, if you see something like this, or you hear about a building that's going through a foreclosure that was financed through the low-income housing tax credit structure, we would really like to know about it, particularly if it's in Pennsylvania. Another way, there are two other ways that a project can be, there can be some exceptions to affordability restrictions. Second one's a qualified contract, which we're not going to talk about here, but we don't need to talk about it here, given, in the interest of time. In Pennsylvania, you can't use this option in order to get relief from affordability restrictions. It's considered waived in Pennsylvania, so we don't have to talk about that. But the third is home ownership in year 15. So remember, this was a 30-year affordability, by federal law, 30-year affordability obligation. After the first 15 years, if the owners of the rental housing have made a promise up front that they would turn the units into home ownership, then after 15 years, they can sell the units, the individual units, to tenants. And at the time that they transfer the ownership interest, then the long-term affordability restrictions are released. So those are really, there are very few exceptions, and we at Regional Housing work with a number of legal aid programs around the country. We're sort of advocates together on monitoring when we hear that there are state housing finance agencies who are letting people out of long-term use affordability restrictions, or if we hear of owners who are trying to get relief from long-term affordability restrictions. So again, if you are hearing of a project that you believe was financed with a tax credit, and you have clients, or you are hearing as advocates that the owners are trying to get relief from these affordability restrictions, we would very much like to know about it. I'm gonna run out of time if I go. Let's just go through the next ones real quick. In order to live, one of the restrictions of living in a LIHTC building development is that all LIHTC buildings are restricted for income levels. And up until 2017, the income limits were restricted to up to 60% of AMI. In 2017, there was a change in structure that now allows the income limits to go up to 80% in certain circumstances, with a system called income averaging. And we're not going to talk about this. We're just going to tell you that you should be asking about when the building came online, if you have tenants who are in the building. If you have a client who's in a LIHTC building, and there's some questions about whether or not they can qualify based on their income. If their income is at or below 60% of AMI, they're going to qualify in almost all buildings. Whether they are admitted is one question, but they should qualify if their income is at 60% or below. And in some instances, it can go up to 80% depending on the building.
Dina, can I jump in for 1 second?
Sure.
something you may want to look for is and I'm sure Tim and Dina are going to get to this, that owners of LIHTC properties in general have to accept housing choice vouchers.
Yeah, that's
So
coming. It's
someone
the next
comes to
step.
them and, okay. So,
Well, no, go for it. Take it.
no,
You take it.
I was only going to
You-
say that the change to allow up to 80% could put some people with a voucher in a situation where the LIHTC rent exceeds the voucher rent, and the owner may come back and say, well, we don't have to accept the voucher in this unit because we could get more money on the general market. And if you have that situation or you see it, please let us know. I think we could help you and help your client in that situation.
Yeah, the argument to allow income averaging in the first place, I mean, that's certainly one of the downsides. One of the upsides is that if you're a LIHTC developer and you can charge, or you can rent to people up to 80%, that means that their income is higher, and therefore the rent you can charge is higher. So you might be able to use some of those 80% units to finance or do a rent subsidy for people that are very low income, at 30 and 20%. So that was sort of I think that was part of the argument behind that change.
Part of the argument, yeah. Can you just bring up, Kim, can you bring out the last piece on this, this particular slide? If a tenant is living in a building that was already where when they entered the building, they entered into a LIHTC building, and at the time they entered, their income was below, say, 60% AMI, but now they've become over 60% AMI. They are protected once they have been initially qualified for occupancy. So people don't have to worry that if their income gets above the income qualifications for that building, say 60% AMI, that they're going to be, that they're going to have to leave the building. What is the next one? Let's go to the next one. Oh, right. So consequences for noncompliance. Many of the participants who are developers in the low-income housing tax credit system are repeat business owners. They do this as part of their business model, both the nonprofit side and the for-profit side. So one of the biggest deterrents against noncompliance is the fact that you want to go back to the allocating agencies where you want to do work, and the jurisdictions where you want to do work, and get another allocation of tax credits. And if you're non-compliant, it could be either that next time you go back and you try to get an allocation of tax credits, you have kind of a stain on your record, or if the way that the allocating agency makes a determination of who's going to get an allocation of credits is based on a point system, you're going to get negative points. So owners of the property, from a compliance perspective, it's both the agency that does the compliance and then they report to the IRS. If there's non-compliant, the owner might not receive the tax credits that it was hoping to receive as part of the benefit of being part of this development. And that's a pretty big deterrent. That's a pretty big stain, pretty big penalty for non-compliance. The allocating agency, in this instance, Pennsylvania Housing Finance Agency, may say you're not a good player, a good partner in this business, and discourage or prevent you from getting a future allocation of tax credits. And state housing finance agencies can create consequences for owners at the discretion of the allocating agency. So again, that's something to advocate for. And Mark will talk more about the role of advocacy as affordable housing advocates, or as advocates for low-income tenants, and how you might use some of that, how you might advocate for certain decisions or certain provisions at the Housing Finance Agency as it relates to either owners and their operations of the building, or on their ability to get a future allocation of credits. But again, most of the people in this business do it on a repeat basis, and so they, probably the biggest incentive is that they want to be able to come back and do more development. Mark, I'm going to let you do this one because you do this really well. This is like one of your favorite things to take through. So
this just shows you the structure of a low-income housing tax credit deal. And I particularly like the colors. So if you have any comments on the colors, feel free to get back. So in box number 1, you have the Internal Revenue Service allocates tax credits to each state based on population. And Pennsylvania currently gets about $35 million of tax credits, or $36 million a year. And that 35 or 36 million equals in the range of $350 million worth of private investment. So it gives you a sense of how much money we're talking about. In box number 2, the state allocating agency, which is PHFA, which we all love, and adopts what's called the QAP, a Qualified Allocation Plan. And it reflects the state's priorities for housing development. And it basically tells developers the type of deals that PHFA is interested in funding, what developers have to promise to do in terms of affordability. Dina mentioned earlier, keeping affordability for 40 years now instead of just the statutorily required 30 years, and having provisions saying you can't discriminate against, as an example, people who are the victims of domestic violence because they are victims of domestic violence. So the allocation plan is about 30-some pages long, and developers study it to figure out what PHFA was. In response to the allocation plan, number 3, developers submit proposals to PHFA saying we would like to develop housing for domestic violence victims or youth aging out of foster care, or to redevelop the public housing units in our community. And they submit them to PHFA. PHFA reviews them, and in number 4, PHFA awards tax credits to some of the developers. In Pennsylvania, it's usually about 3 out of 8 developers, maybe 2 out of 8 developers, or a quarter. And they award them generally in accordance with the priorities that are set in the allocation plan. Number 5, once the developer gets the credits, they sell the credits to investors in return for equity to build the development and operate the development. And generally, investors are, for the most part, banks. Not always. Sometimes there are syndicators who put together groups of people to buy the equity, buy the credits. But, a RBC or a PNC or a Citizens Bank, a lot of the names that you may be familiar with are frequently the purchasers of tax credits. The developer takes the equity they get from the sale of the credits. Frequently, they combine that with other sources of money like community development block grant funds or home funds or fair funds or national housing trust funds. And in general, LIHTC will be about 70-some% of the total housing development cost. In a rural area, it may be a larger amount. In an urban area, it may be a smaller amount. But basically, the developer takes the money, they build it, the building, and they operate it, and hopefully they're providing good housing for lower income people. Number 7 is on an annual basis, the developer submits compliance reports to the allocating agency and promises the agency that they submit a form which they basically promise, they swear, they attest that they are in compliance, certified, right, that's the word I was looking for. They certified to the allocating agency that they are in compliance with all the requirements of the low-income housing tax credit. And that is, in a nutshell, the official process for what it looks like to develop affordable housing using low-income housing tax credits.
Mark, can I add 1 or 2 things?
Absolutely.
Quickly. So One, I just want to explain a little bit on number 5. When we say that the investors provide equity into the deal, I realize that that's the kind of vernacular, that's kind of language that we use. But sometimes people say to me, what's equity and what's debt? And what do you mean by that? So the equity means that the investors are coming into a transaction. They're coming in and saying, we know you, the developer, are going to put together some kind of a project that's going to result in a building or more than multiple buildings. And we want to be we want to be partial owners. And we're going to, in return for getting an ownership stake in that project, we're going to give you cash, equity, cash, to help you build and develop and finance that development. So that's what equity means. It means that they're putting money, cash, into a development.
And can I just follow up there for real quick?
Yeah.
And the other part of that, which number 5 doesn't really explain, is that you don't really sell tax credits.
Thank you.
Right?
We're not supposed to say that.
Right? What you really do is the developers form a partnership, generally. And they don't sell the credits, but they sell an interest in the partnership to the investors, which allows the investors to take the credits. So you can't go to the store and say, hey, I'll give you 5 tax credits for $50. But you can say, I'm going to form a partnership. Would you like to purchase generally
Interest in the partnership, right?
Generally 99.9% of the partnership interest. So hopefully that clarifies that a little bit.
Yeah.
So when you hear people saying they're selling credits, they're really selling a portion of the ownership partnership, the partnership that was formed to own the affordable housing development.
And so if you guys as advocates, and we can get stuck here for a while, but I just like from an advocate's perspective, again, trying to think about this, is that when you look at a building, and we're going to talk about how you'll know whether or not this is a tax credit building, because I think it's Kim, one of us is going to talk about the fact that there is a lease addendum, and there's also an indenture that's recorded against the real estate. And if you see that's an indication if there's an indenture recorded against the real estate that this is a LIHTC building. But when you're looking to see if it's a LIHTC building, it's probably, it's going to be owned by a partnership, and you may not know, like, oh, who's the nonprofit sponsor or who's the for-profit sponsor. So sometimes you have to do a little digging to figure out who the owner is. Usually just this, it's a partnership that was created for the sole purpose of developing and operating and owning this particular project. So if you want to talk more later about how do you know who's the wizard behind the wall and who is the real parties behind any one particular development, we can help you sort of sort that through. But in the interest of time, unless people have a specific question, we should get to getting the answer for Susan of like, what does a deal look like? But just back to Kim, who's very good at talking numbers.
Sure. So here is a really simplified example of how you put together, you're the developer, and this is how you put together your development budget to fund your deal and to basically pay for your construction and all your other costs. They call them soft costs. Your lawyers, your architect, and the other the non bricks and mortar stuff. So let's just take an example. This is let's say that the total cost of your project is $1 million. Obviously, you're not going to do a project for $1 million. It's usually more like 10 million, just economies of scale. But just for the math, we just say it's $1 million. So the first thing you need to do is you need to take out costs not in basis. Now that's if you're an accountant or if you're a depreciation person or an IRS person, that's basically costs that you can't depreciate. It's usually the value of the land. That's something that you have to subtract from your total costs. So you have to figure out what's the cost that I can put in basis and actually claim credits against. And so in this example, it's you take out $100,000, and so your total cost comes down to $900,000. So if you want a 9% credit, that's essentially, it's basically a present value calculation of if you're getting credits every year for 10 years, you multiply that by 9%. And so your annual credits are going to be 81,000. So And then, so over 10 years, so the total award is going to be 810,000. So when Schwartz said earlier, when he was showing you that chart, we get Pennsylvania gets 35 million credits a year, and that translates to 310 million in investment. That's why, because it's an over a 10-year period. So basically, the allocating agency will give you this award. It will give you a piece of paper and it says, you got this award, you won the competitive beauty contest, you beat, you're the 1 out of 4 that got the credits. And so here's the award. We'll give you 810,000. And then you as the developer will go out and into the market and try to find a partner to come in and purchase the partnership interest. And then the partner will, depending on where you are, depending on what kind of project it is, depending on what the investor's need is for Community Reinvestment Act credit, or depending on how hot the market is, they'll bid and give you a price. And in this example, they'll give you 98 cents for every $1 of tax credit. So basically, when you do the math, after this deal, you'll have, it's $1 million total cost in the beginning, and then after you get your award, you'll have about almost 800,000 of the deal will be funded through the tax credit program. So you'll have gaps. And your gap funding is basically, you're going to have to go out as the developer and figure out what that is. So it could be local home money, your local CDBG money. Is that right? Am I saying that wrong? It's your local housing trust fund. It could be PHFA could give you gap funding, although they have a national housing trust fund that could go into these deals. So it's basically up to you, and it's somewhere between 10 to 30% of the deal you might have to go out and raise on yourself. And it's usually, yeah, go ahead, Mark.
And just, I'm sure somebody's going to get to this, but understanding that there's a gap in a deal is important if you're the developer, but it's also important if you're in a legal services program, because while there are restrictions that come with LIHTC, there are other restrictions that come with the gap funding. So if it's CDBG funds or home funds or whatever the other, it could be rental assistance funds. It's really important to know what the gap funding is, because the restrictions on the owner and the rights of tenants may be stronger.
So Mark, how would you know that? So can you give them an example of where you would find out that information?
Well, why don't you do that? Because that's a very good question.
So not to deflect too much from where Kim is going on this, but that Mark is right. If the project has additional sources of funding in it, that LIHTC is the base, right? That's the requirement. So you have to comply with the LIHTC program. In many, many, many transactions, particularly in cities where the cost of construction is high, or there just happens to be more federal aid, or there's a housing trust fund where those funds can be set aside and used for affordable housing development. There may be other obligations that come with those other funding sources. Typically, if it is coming from any one of a federal agencies or a local agency that is administering federal funds, they will secure their obligations. They'll put money into a deal, and for other reasons, including that just long-term restriction, they will put a mortgage on the property and make, any funds they're putting in, they'll put in as a mortgage, they'll put in as a loan, and they'll secure that loan with a mortgage. But they will also have some kind of a regulatory agreement or a restrictive use agreement on the real estate. So if you're trying to figure out, what were the sources of funding for this property, and maybe, what are and how might this project be obligated by law as to limits on income or other kinds of restrictions, do a title search and find out what are the restrictions against title, and see whether there's a regulatory agreement, see whether there's a mortgage, see whether there's a use restrictive agreement somewhere that's recorded against title. Increasingly, even in Pennsylvania, there's all kinds of people are so desperate to meet that gap that, not desperate, but they're motivated and creative for meeting the gap, that there are some now kind of nonprofit funding sources too that might say, we're going to give you money. And in return for giving you $100,000, you have to promise that 3 of the units might be made available to somebody who has intellectual disabilities, but who is able to be employed. And so you might want to see whether that's one of the obligations on the project. It certainly wouldn't be on every unit in the project, but it would be an obligation of that particular developer once they got the money to meet those requirements as set forth in whatever the restrictions are against the real estate.
And if you find one of
That
these
makes sense.
deals and you get stuck, calling Dina or Kim or somebody at Regional Housing can certainly help you
Yeah.
try to figure this out.
Yeah. It's not obvious to the naked eye, so you have to do a little digging. All right, Kim, sorry. We digressed.
Next slide.
I think so, yeah.
This is
Oh,
Kelly.
pretty-
If I can
That's
just
fine.
launch the first of the CLE poll boxes, you'll have a minute and a half to respond. Thanks. And Dina, please feel free to continue.
Sure.
Thanks.
Yeah, here comes the part that you guys really probably were waiting for, because all the rest of it is, like how is a deal developed? But now you're going to get to the part where Kim's going to talk about rental use restrictions, because she's really good at that too.
Yeah, my mouse has stopped working, so.
Oh, I know if can I do a share? Can you make me,
Just lost.
let's see. We have the, uh-oh.
It was probably because of the poll box. Sometimes
Yeah,
it does that
probably.
randomly.
Yeah.
So see if you're able to do it now. Oh, Kim
Okay.
froze up. There you go. See if you
Is that
can
better?
advance some slide.
Okay.
I think Kim
This seems
froze
like it would
up
be a good
again.
time to get cookies.
Sure. All right. So I guess this is I'm taking over here. So
Yeah.
everybody can hear me and I'm not frozen. Okay.
You look frozen, but you're not sounding, oh, there you go.
Now we
great.
see you.
Okay,
Now we
great.
see you.
Thank you. Okay.
I'll do it if I need to.
So let's see. So just like other programs, LIHTC imposes both a maximum tenant income and a maximum rent that the landlord can charge. So, and the income is based on the HUD's area median gross income. So it defaults to the metropolitan area. So it's often county-wide, but if you're in a metropolitan area, it could cross counties. And there's a picture of St. Louis and then East St. Louis. Okay. So it can cross state lines too if you're in the metropolitan statistical area. But anyway, so how is LIHTC rent determined? So one of the quirks about LIHTC is the way rent is determined and how it often may result in your client paying more than 30% of their income towards rent because of these little quirky rules. So I'm going to try to give you an example so you can really understand that. So it's not based on your client's income, it's based on their imputed income. And the imputed income is determined based on the unit. It's basically tied to the unit and it's a bedroom size and it's also what kind of unit is it? Is the unit targeted for families that are making 60% area median income? Is it targeted for somebody making 50%? Is it targeted for somebody making 20%? So that's all going to really determine how the rent is the maximum rent is calculated. And it's not based on the actual income of your client. So, and the weird, and I see somebody with a question. So if Dina if somebody else could monitor, I'd be happy to answer those. So.
Oh, Gary wants the poll box back up.
Oh, okay.
It's all about the CLE.
So I'm not going to put the poll box up. Excuse me, put the poll box back up. If by chance you didn't happen to have time to respond, please just chat box me your name and I will make sure you receive credit.
Great. So the quirky rule is that one bedroom is, if you're in a 1-bedroom unit, it's basically 1.5 persons. So you have to go to the 1.5 persons area median income, and you have to figure it out from that. So let me give you an example, right? So this is so in Dauphin County, a 4-person family at 60%, they can't make more than $48,660. This is actually 2019 figures. I didn't update it for 2020, but because it's just been such a crappy year that I'm going to pretend 2020 never happened. So anyway, so if you're just trying to figure out what's 30% of what would a family making that, what would be an affordable rent if they're not paying more than 30% of their income, then you do the math, and it's basically you divide by 12 and then multiply by 0.3, and you get they're not going to be paying more than $12.16 a month. So that would if you're using that 30% rule. So that's basically, that would be affordable. So carrying over that 40 affordable rent, in the LIHTC program, that works if you're a 4-person family and you're in a 2-bedroom. So what the LIHTC program does, it doesn't look at the fact that you have a 4-person family. It looks at how big is the unit you're in. So if you're in a 2-bedroom, it assumes that there's going to be 3 people occupying that. So it looks at the 3-family median income at 60%, and somebody so that figure for Dauphin County in 2019 was $43,800. So the maximum rent the landlord could charge for that unit under the LIHTC program is $1,095. So in that case, $1,095 is less than 30% of your income. So that rent would be affordable. So you're a little squeezed in because you're only, it's 4 people occupying 2 bedrooms, but it's basically, yeah. So then if we change that and say that you're going to go to a 3-bedroom unit, then you're going to end up being rent burdened. So you have the same family, same size, same 60% unit. If you do the math, under the LIHTC program, the landlord's allowed to assume that 4.5 people are in that unit. So if you actually go to the charts and see what a 4.5 person family, the area median income at 60%, it would be 50,000. And in that case, you do the math, and the most the landlord could charge there is going to be $1,265, which is a month, which is more than what 30% of your income is. So therefore the rent would not be affordable. But it's not by much in this example. But that's basically shows you that ways in which the rent could be more than 30% of your client's income. Now that's often going to be the case. Basically all families making less than the maximum income are going to be paying more than 30% of the rent, unless the landlord charges less than the maximum rent. And there's usually not a whole lot of incentive for a landlord to do that. Or if the family economizes by living in a smaller unit, provided that's allowed, because they might have some standards they have to, or if they have a voucher or subsidy. And this is also, if your client is, you might have a client that could qualify for a 50% unit, but the only units that are now available are 60% units. So that would even put more burden on your client. So, it could be that the landlord or the management agent would do the rental application and see that, hey, even though you're only making 50%, you want to get into this building, only 60% units are open. We find that you have enough income to occupy the 60% unit, but we're going to charge you the maximum rent, and so you're going to be paying closer to 40 or 50% of your rent. Of your income towards rent. So that's sort of the quirk of the LIHTC program, is that often clients are going to be paying more than 30% of their income unless they have a voucher or rent subsidy. So this is an example of, this is a study that's often cited because it was really very useful, but it's kind of old. It's from 2012, but this basically shows rent burden households, and it compares people in LIHTC units with people, the general population. And so the bigger blue, the darker blue you see on this is the more rent burden. So if you look at this, really the tenants that benefit the most, the LIHTC tenants that benefit the most, in other words, have the least rent burden, tend to be in the lower 30% units, because usually those come with some kind of subsidy, some kind of operating subsidy. so that allows them, so they're paying less than, or closer to 30% of their income towards rent. When you get to the 31 to 50% AMI tenants, the people earning that, they're not extremely low income, they're just low income. They tend to be more rent burdened. So there you go. You have, you see a lot of blue there. So that's sort of the quirk of the example I showed you before. You're often going to be paying more than 30% of your income towards rent, especially in those, if you're in a 50 or 60% unit. Okay.
Hey,
So
Kim,
yeah.
I think we should stop to see if there's any questions.
Yeah.
Like, is anybody willing to say they have a question? Or, I mean, for us, I will say that even for us, we're like, there are a number of maps about what is the maximum rents that can be charged per unit. There are multiple funding sources that are now used to provide support and operating support, some coming from housing agencies, housing authorities, some coming internally that people might take a portion of the money they have for the project and set it aside. Some of it might be coming from other agencies. It is like a very, very complicated process. But if we kind of want, like, this is sort of the crux of how rents are calculated. And, I know that sometimes that tenants do sometimes go to legal services office and say, they charge me too much, or, they rejected me because I couldn't make this rent. So if you have any questions, we can hold them and you can ask later, you can send a chat and email us. But if you want to talk about calculating rents, we'll do our very best to try to make it English, like Kim, Kim always does this because she's way clearer than me, but like it is complicated. So if you
and often
want to talk about it, we're really happy to talk about it.
I would say often you may find somebody coming to your office saying, but the person down the hall pays a different rent than I pay.
Yeah.
How's that possible? And I think when you look at some of this stuff, somebody's in a 30% unit, somebody's in a 50% unit, somebody's in a 60% unit, somebody has a housing voucher. There's many, many ways within the purview, the parameters of the LIHTC that people could be paying different rents. It doesn't mean that someone made a mistake or that they're discriminating against anybody. Now,
they could have made a mistake. So it is
right.
important to check it, but it doesn't mean that you're being discriminated. It just might mean that it's just that there's a difference, right? Yes. I'm also going to say it's 5 of 3, so I'm going to. Yeah,
right. And I guess one important point I want to make about Rant is the lower income units, the ones that are targeted to lower income families, like 30 and 50%, are often, they often disappear and get rented up more quickly than the 60% unit. So your client may be in a 60% unit, even though they could qualify for a 50% unit. Right. So one thing that it's important for your clients to be able to ask is there a way I can get my unit requalified? And it wouldn't necessarily mean they have to move, but because often the units are floating, but is there a way I can, be qualified for a 50% unit? Is there an opening there? Maybe at recertification, that's something that you should ask, especially if they're struggling.
Or a 20% unit. I mean, every development should have a percentage of units that are rented to people at 20% of AMI. So no matter where it is, all the units currently being developed in Pennsylvania have some percentage of units being developed for people at 20% of AMI. So
the reason why there's so many of these different levels, the 20% is in part a response to advocates pushing to make sure that there were lower income units, that every project had a set aside of units for people that were very, very low income. And the remainder of this 40 and 60 and 50 comes from other statutory parts of the LIHTC structure, which we won't bore you with. But it's not just because people are trying to be like nifty about income levels. It's because they're sort of required by law.
Well, and they're also, and then I'll shut up for a minute, but also when we went back and talked about a qualified allocation plan earlier, there's a priority in the allocation plan for people who rent more units to tenants below 50% 40%. So if a developer wants to get credits, it's an advantage to them to promise to rent more units below 60% of median. And that's what the reason a lot of people have different levels of units.
Dina, was there a question that you wanted to answer?
No, no, I just chatted. There was like, where's the list?
Oh, got it.
I
Okay.
just chatted it back. The PHFA has it. I chatted it back. There we go.
Okay, so let's see. So let me talk briefly about evictions. So LIHTC, in the LIHTC program, owners are prohibited from evicting residents other than good cause. And so this is mandated by the IRS and also by PHFA. And so PHFA's, so I skipped ahead since we're running a little short on time. So PHFA requires that all LIHTC units have basically a PHFA lease addendum, and I think it's a 1 or 2 page addendum. It's clearly marked at the top, and one of the things that says on the lease addendum is that you can't be evicted except for good cause, and it defines good cause as serious and repeated violations of the lease.
And Kim, could I say, one of the reasons there is a lease addendum is that legal services programs, before there was a lease addendum, would have clients come in, say they're in a LIHTC unit. The legal services person will go to court and say to the judge, well, my client can't be evicted except for good cause. And the owners would say, no, this isn't a LIHTC unit. And the legal services people would then have to go to the courthouse or wherever they record deeds, get a copy of the lease of the restricted covenant agreement and come back to court to show the judge that it really was a LIHTC unit. And this happened many, many times in Philadelphia. And I think they're the people in Philly brought this to our attention, and then we brought it to PHFA's attention. But that is a reason that we do have a lease addendum, is that owners frequently denied that the units were LIHTC units to the local judges. Sorry. I just thought there was a good background there.
That's good. And so the lease addendum also, not only does it define good cause, it should have, it has a provision that protects victims of domestic violence, so they can't be evicted for too many law enforcement calls to the unit to protect against an abuser, and and it also says that you have to basically lease. It has to the unit has to be leased in compliance with the Fair Housing Act, and it also, you can't discriminate as a landlord. You can't say, if you're in the LIHTC program, you can't refuse to take someone because they have a Section 8 voucher. So
Even if they're not therefore going to be able to achieve, if you're in an 80%, they just basically can't discriminate against voucher.
yeah, I guess, yeah.
Sorry, I didn't mean to step in. I was going to try to.
No, that's fine. Yeah.
You know what? You can't do it, right?
Right. I mean, yeah. So, so this is sort of good cause in the tax code. I'll sort of skip over this one. So PHFA recently sent a reminder after some advocacy work that CLS did, and in conjunction with Regional Housing Legal Services,
And
basically
PLA.
sent a reminder that you can't. So failure to renew a lease at the end of its term does not constitute good cause eviction. So there's so that's an issue that's hot now with the moratoriums, and whether that's but that's a specific. So let me run to let me skip over this, and if so in 2016 CLS did a study of evictions in LIHTC developments and found that there were 563 complaints included termination of term as one of the reasons to evict. And so 47% of LIHTC developments filed at least one complaint that included a termination of term. And that's clearly a violation of what we just saw, and a violation of PHFA policy. So it looks like, there are some particular bad actors. One law firm in particular filed them, and 9% of the complaints were by one particular owner. So what we did is a a lot of these developments also had PRA funding, Philadelphia Redevelopment Authority funding. It's that soft funding that fills the gap that we talked about earlier. And so, PRA stepped in and informed LIHTC owners that this is, you can't be doing this, and you're going to develop, this is going to be serious consequences for this development and for your ability to continue to develop developments in the future. And as we said earlier, this is their business. If you're a developer of LIHTC units, that's your business, and you have to be on the good side of the funding authorities. And PHFA sent that notice that in their newsletter to people that end of lease term is not good cause. So and then we also did some training with property managers to remind them of that, property managers. So Mark, is there anything else you want to talk about on this particular issue before we jump?
Only that if you see this happening in LIHTC units, please let us know.
Yeah.
Right, and this is something that's very easily corrected. PHFA will take action against owners who terminate a leasehold at the end of the lease term improperly. So if you find this, let us know.
There's a question that's on the chat, and I'm answering it. You'll tell me if I'm answering it wrong. The question is for tenants who are having habitability problems in a LIHTC unit, what common area is not being maintained? Is that a place where you can involve PHFA to force the landlord to make the repairs? And my answer back is we should talk about it. If it's a pattern, if the owner is not responding, if there's been repeated requests and it's sort of, some kind of a pattern. I don't know if PHFA would intervene if there was, just sort of one unit, one tenant, one problem, but they might inquire. But if it becomes a pattern, I think that I don't know, Mark, you may have a different interpretation. I think they would want to know, particularly if the project if they're being non-responsive and it's, a true habitability issue.
Yeah, I mean, if you're really talking about a habitability issue, again, I would encourage you to call Kim or Dina or somebody at Regional Housing, and we could try and help you.
Yeah.
I mean, if the question is that the hallway is dirty and, I think that's
property manager, right?
Right. But I mean, the first step is to go to the property manager and then go to the owner. And if that doesn't work, I think we could help you, particularly if it's a habitability issue. There's a form called Form 8823 that's filed against developers who are not complying with the requirements of the tax credit program.
PHFA files it and submits it to IRS.
And if you remember from the chart we showed, that was that was number 7. Yeah. It was non-compliance, and PHFA has an obligation to monitor for compliance. So that's part of what their responsibility under the law is. Yeah. And they do file. And if you go to, say, number 7, developer submits compliance reports to the allocating agency, and the allocating agency has an obligation to monitor for compliance. So the agency files many 8823s a year. The consequences are really significant. This is not like a HUD program where if you don't comply with something, a court will say to the owner, go comply. Here, if you don't comply with habitability standards, the consequence to the owner of PHFA filing an 8823 form could be tens of thousands, if not hundreds of thousands of dollars, depending upon how pervasive the noncompliance is. So there's a significant monetary incentive for owners to remain in compliance and not have 8823s filed. So it's a long way. It's a long way of just saying, if you see habitability issues, talk to the manager, the owner, and if that doesn't work, talk to us.
The other thing I want to say about because Kimberly talked about tenant and eviction issues, we work with our clients as they have to put together tenant management plans. And PHFA is pretty rigid and it's pretty rigorous. And, every project has to have a language access option. They're pretty rigorous on accessibility. They're pretty rigorous on fair housing. There's a lot of certifications that owners have to comply with. They then, if they hire a property manager, they may try to impose some of the contractual obligations on a property manager. But at the end of the day, the owner's bound by a number of obligations that are imposed as the owner of a project. And they have to have their lease can only include certain information, not other information. So again, if you're in it with the LIHTC deal, I would encourage you also to ask for a copy of the property management plan, the tenant selection plan, etc. Kim, did we lose your sharing slide?
I'm just skipping ahead. So,
Oh.
okay. All right. So, okay.
And whoever just said they'd like to, we saw the chat, we'd be happy to talk with you. You trying to get to Mark's part?
Yeah. I guess let's go ahead and start doing that. Yeah, actually,
I do
what
think
is the
we can
restricted covenant? Do we want to spend a word talking about
Someone
that?
should discuss it. Someone should talk.
All right, I'll do it really quickly. I was going to do this, but I'll do it really quickly. The obligations under the low-income housing tax credit in return for getting an allocation of credits, you, the owner of the property, you are mandated to put a restriction of use and have it recorded against the title of the property that just got the tax credits. So it's called a bunch of different things. Sometimes it's a land use restriction agreement. In Pennsylvania, it's called an indenture of use restrictive agreement. It must be filed against the real estate, and in Pennsylvania, it gets filed at the time that essentially the agency says, okay, you're ready to start construction, just call it that. And you should be able to see it. It is mandated by federal law. It includes a number of the obligations of that particular developer and that owner of that real estate. Sets forth some of the tenants' rights, but one of the important things in it is that it articulates in the LURA, in the indenture restrictive covenants, that tenants are third-party beneficiaries of the interests in the real estate, right? So it's an important thing for tenants to know that they have rights that are associated with the fact that this property is a LIHTC property. So we can walk through it, yeah.
I don't think we could.
We're not going to talk about it. We're
not going to go too much into detail, but you have to know that one thing. If you learn something here, that the restrictive covenant and the things that the owners have agreed to do are enforceable by current tenants, past tenants, and future tenants.
Right.
And
those who would be eligible.
Yes. So I think, from a legal services program's perspective, this is incredibly important to be able to go into court and say, my client is a third-party beneficiary pursuant to federal law, and here's a copy of the agreement that says that. And there have been cases, there was one in Oregon, and there was just recently one in Hawaii, which federal courts have recognized and the rights of tenants to enforce the affordability provisions of the LIHTC.
And it's where if the project just says it's 40 units, it will say in the LURA, the indenture, 6 of the units must be set aside, or 4 of the units are set aside for people at 20% income, and 20 units are set for people at 50% income, and the remainder at 60%. Is that important? Maybe, maybe not, but at least that's one of the places where you'll find that information.
Yes, and that is the form that the people in Philadelphia would end up having to go and get and bring into court to prove to the judge that there were good cause restrictions on the properties.
So the lease addendum and the LURA, those are two things. If you have a tenant that's a client that's come in and they say, I think, you say, is this building qualified, paid for with tax credits? And they go, I don't know. You can say, let me see a copy of your lease. And then if that doesn't help you, you can say, let me go look and see what's recorded against the real estate and start to look for something that says the LURA, indenture, restrictive use, something like that.
And you can often do that. Go ahead.
I'll say real quickly that if you get tenants coming into your unit on a LIHTC unit and they don't have the lease addendum and it's not attached to a lease, you should let us know.
Or tenants lose things, Mark. There is people who you know what I mean? Was it issued to them? There should be some indication, but you should ask them and they should have it, or the property manager should be able to produce it for you.
Right. And if, you can look it up on your own. You don't really need to get a title company to do it, although you know,
People lose
in
things.
these days, it's almost it's easy as getting a docket. I mean, most land records, they're county based, and they're you know, you can search on the address and find it. I mean, it takes a little bit of real estate knowledge to really understand it, but and to understand all the things that are recorded against the land, you know, the mortgage and the all the soft mortgages and that kind of thing. But you can usually find an indenture pretty easily on, you know, a lot of the county. I guess it's the land
Recorder
records.
deed, yeah, the land
Order
record.
of deeds, yeah. So, okay. So QAP, so we can talk about the QAP and advocacy. Mark, this is your.
This is your time. Your non-cookie time.
Okay. So in terms of advocacy, one of the things that part of the LIHTC process that's subject to a lot of advocacy, or could be, is the QAP. And, you know, we talked earlier about the provisions that the allocating agency, or in Pennsylvania, PHFA, put into the QAP, and it may impact the type of developments that get done, the location, the type of ownership. So as an example, in Pennsylvania, 25% of all the credits have to go to nonprofit developers. There are set-asides for developments that target vulnerable populations. So if you're developing housing for a vulnerable population, what's called supportive housing, Pennsylvania provides a priority to developers who do that. The QAP has to contain provisions relating to noncompliance that we just talked about. So the QAP is a point of entry for advocacy, and it's developed basically on an annual basis. It's made available to the public, and PHFA is going to be sending out in the middle of October, their changes to the QAP, which people can then respond. And you could say more units should go to very low income people. People shouldn't lose their house due to
COVID-19.
well, whatever. People, if there's redevelopment, you shouldn't be relocated without having the right to come back. There's any number of there's any number of issues that could be in a QAP. The three preferences that you see at the bottom are for the lowest income for the longest period of time, and in qualified census tracts contributing to a concerted community revitalization plan. So if you have any clients who are interested in this, or you're interested in participating in the QAP process, again, let us know. PHFA is somewhat responsive to these type of issues, and it's worth spending some time. I know a number of legal services programs in other parts of the country have gotten involved in areas of opportunity, trying to direct credits to areas where there are high opportunity areas, where there's good school districts, and there are lots of job opportunities. And I think, you know, Ohio is a good example of that, where they did a lot of advocacy and really changed the way the LIHTC was allocated. Just as an aside, that whatever you provide a priority for is going to take away from something else. So no matter how good the use that you're talking about, whether it's domestic violence victims or seniors who are in need of supportive housing, given that there's a limit to the number of credits, it just means something else is not going to get credits. And if you're allocating credits, you know that. In Pennsylvania, there's a restriction on displacement, and the people who are currently in properties are, to the greatest extent possible, feasible, supposed to get first crack at the redeveloped units. I'm not sure it always happens, and that sometimes people get lost when they've been temporarily relocated. But again, it's another issue which if you see happening, we'd be very interested in helping with. So I think the key issue that I want to get across is that while LIHTC is a provision of the tax code, and Dina and I argue about this and all the time, it's a program, it's a provision, it's administered by PHFA in Pennsylvania. The PHFA has 14 board members. They're appointed by the governor, the legislature, and they're ex officio. And if you want to be involved in this area, it's important to develop relationships with both the PHFA staff and the PHFA board members when you can do that, right? I'm on the PHFA board. I've been on it for a long time. I'm the vice chair of the board, and owners and developers want to, as Dina said earlier, keep in good relationship with the agency. So when issues come up for your clients and you understand what the law is and you understand what the regulations are, one of the first things I would say, and I say this all the time in response to the National Housing Law Project's listserv, is if you think your client is being not treated fairly, first I would say is call the owner, call the manager, and then call PHFA, right? Holly Glauser is the person at PHFA who is in charge of the tax credit program. And I can see her with a gun ready to shoot me while I'm saying this. But if you can convince PHFA that you're right, you're not going to have to go to court. They will call the owner or the manager up and tell them to stop doing what they're doing. And that's going to be way more effective than you spending your time in front of a district justice who may or may not understand what's going on. The second thing, again, is if you know a board member, right, of PHFA, and I'm just counting myself, right? But if you know another board member of PHFA, they could also help. And they could help by, number one, calling the owner and manager. Because as Dina said earlier, the people who own and manage these developments do this over and over again. They want to get additional allocations of credits. And while the process for allocating credits is somewhat objective, it's also somewhat subjective, and having the support of your local elected official does factor into developers getting credits. So if your state senator is willing to call either PHFA or the owner and say, I have a constituent who has a problem and I really need you to help them solve it, that could be way, way more effective than anything you're going to do in court. That could be one phone call and you'll get your client, hopefully get them what you want. And I can't tell you how many times I've given this advice to people throughout the country, and I get these emails and phone calls back a month later, 2 months later saying, you know, that really worked. We did call whoever it was. So people who have influence in this process are your congressman, your U.S. congressman, your U.S. senator, your local state rep, your local state senator, all of whom the owners want to maintain a good relationship with. So even if it's something's discretionary, right? Like it's like, can you help my client move from a 60% unit to a 30% unit. Well, you don't have any right to get your client to move from a 60% unit to a 30% unit, but the owner may look for a way of doing that just to keep either PHFA or the elected official happy. And again, uh, I would say that this is very, very similar to, I'm Jewish, right? And what I would say to people is, if you read the Bible, you're not going to learn really how Judaism's practiced, right? It's really what your rabbi or your local community. And you could read all the federal regulations and you could read the QAPs, but on a daily basis, what's going to have the most impact on the QAP, on how you represent your clients, is knowing the pressure points of the Housing Finance Agency, knowing the pressure points of the owners, and advocating with those pressure points. And again, I think you could go to the next slide, but and we only have 5 minutes left. But these owners and developers want to do this over and over and over again. And they want to get additional allocations of credits, and they want to maintain compliance. And the way they do that is stay in good stead with all the people that we've mentioned, particularly the staff and board of the allocating agency. So you're not going to find that in any textbook anywhere. You're not going to find that anywhere in a IRS guideline, but that is how this stuff works and how you could really do a great job of representing your clients. So I understand there's only 5 minutes left and I'm going to shut up again, but just think outside the box. And if we could help you do that, we're more than willing to do it. Dina, did I finish in time? You're muted.
I told our CFO that I would put $1 in the kitty for every time I spoke when I was on mute. So like last month was $15. So there goes $1. But we went, Mark did finish in time. Do anybody have any questions? Do they this is kind of odd. It's not like traditional legal aid work. We know that. And our real goal is to be able to help translate this stuff into something that you guys can use to advocate for tenants. We are in such a hard space for tenants right now. We just want tenants to be in the best position they can be, and that you as advocates are in the best position to represent the people who so desperately need affordable housing. So any part of this, if you have a question or anything that's remotely, connected, we'd be happy to.
Yeah. But I think the main thing that we wanted to get across is we're here. And we're here to try and help you guys. We understand that what we do generally is more on the development side than the operational side, but we do understand the operational side and want to be a resource. Want to be able to help you represent your clients.
This is Kelly. While we wait to see if anyone's going to type any questions in the chat box, I'm going to go ahead and launch the second of the CLE poll question boxes. Please respond to that for CLE credit attorneys on the webinar. And again, if anybody has any questions or comments, please type them in the chat box now.
Finding of these polls. Sorry, go ahead.
If you don't have any questions, we really want to thank you for sitting through this. The thought of, I don't mean that disrespectfully to Kim and to Dina, but the thought of sitting through an hour and a half of basically tax code stuff can't be a joy to everybody. But it does have significant impact. There are 2 times more LIHTC units throughout the country than there are public housing units. So it just gives you a sense of how extensive the number of LIHTC units are.
So now I'm going to do a dramatic reading from the section 42 of the tax credit code. So if you guys want to stay, actually, I think the timing of these polls is somehow related to the time of day, the day of the week.
The fact that people didn't leave yet, right? Like, very clever, Kelly, to keep it at the very, to make them have to sign in again at the very end. There's a whole bunch of other things on this too. Like, you know, we didn't talk about the student rule. We didn't talk about, well, I guess we didn't talk about,
We
there's
could,
a- you know,
and
we could, but
we could do LIHTC 102 or
Don't scare
202 at
Don't
some
threaten.
point in the future to get into some of the more details. And maybe we'll talk to Kelly about that after this is
if
over.
people really want it. I mean,
Yeah.
you know, you could also just say, and we could also, I think, you know, try to do a better job of making sure that there are materials that we have that we can access to share with you. Like a lot of the materials that we have that we use within the confines of our own office are sort of the technical aspects, but there are materials that we can help generate, I think, and we can send your way that have to do with the, you know, kind of the more advocacy side of this. And we are actually working on developing some of our own. So hopefully, well, that will be soon.
Thank you, guys. I'm going to head out.
Minute early.
It was, well, it's 3:29. We have 1 minute. It was great doing this. It was great seeing everybody's name and torturing you for an hour and a half. So, and it's great to see David Gates's name, who I haven't seen in a while. And hi, David. All right, enough. Bye, guys.
Okay.
Bye,
Thank you.
everybody. Thank you very much. Thank you to Plan for
Thank
giving
you.
us this opportunity.
Thank you, Plan.
Have a
Thank
nice
you.
weekend,
Have a
everybody.
great weekend. Take care, everyone.
Thank you,
Everybody.
Kim. Thank you, Dina.